A 5-judge constitutional bench of the Supreme Court has reserved its judgment in a very important batch of petitions. These petitions challenge the constitutionality of the electoral bonds scheme. Electoral bonds are used as a tool to make donations to a political party. However, the name and other information of the donor are not entered on the instrument, which makes these donations anonymous. The Association of Democratic Reforms, the Communist Party of India Marxist, and Dr. Jaya Thakur of the Indian National Congress challenged the amendments to the Finance Act 2017 that made way for the electoral bond scheme. During the hearing, the Union government defended the scheme as a method to ensure taxable white money is used for political fundings, and contended that it was necessary to keep the identity of donors confidential to make sure no retribution comes to the donor from political parties. During the hearing, the bench raised several questions to the government about the selective anonymity of the scheme, as it was observed by the bench that it was possible for the ruling party to know the identity of the donors, but the opposition parties cannot get such information. The CJI D.Y. Chandrachud also expressed displeasure with the Election Commission of India for not having the data of the electoral bonds donation till date, even though the Supreme Court had passed an interim order in April 2019 to maintain the data of the electoral bond fundings. However, the CJI clarified that the Supreme Court will not ask the State Bank of India to reveal the identity of the donors at this stage. While concluding the hearing on November 2nd, the court also directed the Election Commission of India to submit to the court the details of the contributions received by all political parties through electoral bonds till September 30. You can read the April 2019 order and the daily updates in this hearing from the Supreme Court on our website at www.livelaww.in. And for more legal updates, please follow LiveLaw.